May I please, Your Lordship?
1 second.
May,
Just 1 second.
At this proceeding, but I am appearing on behalf of the major Milord Industry Association, which is the ASSOCHAM, UK Milord, and CI. But we have filed applications today morning. Lord,
If the application is not numbered, it is not registered, we'll follow what sauce for the goose is sauce for the gander. Mr. Rodhi, sorry, no oral mentioning in my court.
No, I'm not Milord. I'm in the matter. I'm saying. I am saying.
We have no such application on board. Let it be circulated. We'll deal with it in the normal course.
But Milord, I am respectfully submitting. If
Sorry, appearing for big
today,
clients, we will not tolerate this. You have to follow the rules in my
but
court.
Milord, if you Lordship make an order today, my application will be infructuous. I am saying kindly defer the issue of grant of alphanumeric.
Mr. Rodhi, you are aware about these proceedings going on. You could have intervened at that stage. What is this after the judgment is passed? You want to intervene now?
No, Milord, the order is of 15th March.
No, but you are aware about the proceedings pending before this court.
But we were not parties anywhere. We were not parties at any time.
Everybody, the whole world knew that this matter was being heard.
Milord, I have
Come back 1 second, Mr. Rodhi. You come here after the judgment is delivered. You are now, you file an application. That's not the way.
Milord, I have come only in regard to
Circulate
15th March. Kindly appreciate.
No, Mr.
I have no problem in
Rodhi,
declaration
hear you.
of the list of donors
Rodhi.
or the list of recipients.
Mr. Rodhi will not hear you right now. We have a specific application which is on board. You ask your advocate on record to follow the procedure. File an email. It will be dealt with by my registrar listing. We'll take a, we'll get it. No.
I am saying
No,
kindly. Milord,
If I do it for Mr. Rohatgi, senior
No, no,
counsel, then Mr. Rohatgi, you look at me. As Chief Justice, I have no face to tell all the other juniors to whom I declined list mentioning in the morning. What sauce for the goose is sauce for the
I am
gander.
not mentioning, I am not appearing in the matter and making a submission.
We have no such application on board before us.
Milord, I have got it with me.
I've made my
my Lord, the entire,
I have emailed
entire judgment
One
has.
second, you wait. One at a time. Sorry, Mr. Rodgi. Yes.
No, my Lord, my submission is the entire judgment has been rendered behind the back of the public at large. This judgment doesn't constitute restitution. This judgment doesn't constitute restitution.
1 second.
Yes.
1 second.
This
1
judgment is
second.
void.
Please listen to me. You are not, 1 second.
I am a citizen of this country.
1 second.
Yes.
Don't shout at me.
No, I am very soft.
Please listen to me.
Yes.
This is not a Hyde Park corner meeting, okay? You are in the court.
Yes.
You want to move an application?
No, my Lord.
File an application. What I told Mr. Rodgi applies to you.
No, my Lord, the question is, my Lord, this,
There's no question you've got.
my friend has come.
Mr. Nedumbara, 1 second.
Yes.
You've got my decision as Chief Justice. We are not hearing you. If you want to file an application, move it on the email. That's the rule in this court. No further.
We will go by what your lordship.
All, please.
Whatever your lordship says, we will go by that.
Do you want another contempt notice?
No, my Lord, your lordship will go by
You have
whatever
had
your
enough
lordship
submitted
says.
Bombay.
Only I have said what I wanted to say. That this judgment is rendered behind the back of the people of this country. It doesn't bind us. It doesn't constitute. It is not a representative
Do not,
process at all.
please, once we have said no, please move the
I
application
accept
by email.
what your lordship says.
Do not continue and persist.
Yes, I only said it was not a representative proceeding.
You are
All the way come from Kerala.
You are obstructing in the administration of justice.
Pardon, my Lord?
You are obstructing in the process of administration of justice.
The entire judgment is against behind the back of these people. Parliament has been rendered
Hey,
irrelevant.
That's all. That's all. We heard please, that's all. You made it.
We are in a democracy.
We will not hear you till you follow the procedure prescribed.
We are filing it.
Please do.
We are filing it.
Please do. We'll consider it afterwards.
That's
That's
it.
it.
10 o'clock.
I-
My friend came from Kerala to took a 1 o'clock flight.
Have not-
Be kind to us. Be kind to
That's
us.
all, please. We will not hear that.
In
Please
democracy.
call for the application. Please follow the application.
Democracy.
My lord, may I mention, my lord, my petition for suo motu that is pending. Whatever lordship want to do, that do only. I will not disturb lordship.
Mr. Agarwala, apart from being a senior counsel, you're the president of the SCBA.
Yeah.
You should know the procedure. You have written a letter to me asking me to invoke my suo motu jurisdiction.
Yes, yes, my
You
lord.
have no locus to mention
So
anything.
that I should not
You
disturb
have to
lordship.
restrict what you
We
have
should not waste it honorable time, court's time.
Fair
That's
enough.
why.
Lord,
Only that.
These are all publicity-oriented stunts. We will not permit it.
Not a handmaid of a.
Whatever
Please,
lordship feel better.
Mr. Agarwala, please keep it at that. I may have to say something more, which will be perhaps a little distasteful.
My Lord,
Please close it.
members of the bar who are senior
Mr.
to your lordship.
Medumbara, it is enough now.
Also senior to your lordship.
It is enough.
65-year-old man, Lord.
Be kind to us, later. We are very polite and begging with your lordship. Your lordship has it's a soft language.
Madhupara, we have been telling you that you are interfering, you're obstructing us.
No, no, no.
What is
How
that?
can it be said?
Now, if you don't stop, we will have to.
When we are not heard and we feel threatened. Sorry, my lord.
Follow to the left.
Yes, Bala. Yes, hearing now. We issued notice on the last occasion to State Bank of India. Mr. Kapoor, you are appearing? You are appearing for,
I appear.
Mr. Salve is also there.
for the State Bank?
That's right.
Yes.
But I appear for the State Bank.
Yes. Mr. Salve, in
Yes.
our order which we, in the judgment which we delivered, we had expressly asked State Bank of India to disclose all details. The language of the judgment was all details have to be disclosed. Therefore, that includes the bond numbers as well. So,
But I,
let SBI not be selective in the disclosure of details. We intend
But I-
to clarify that it shall disclose all details, including the bond numbers, and every part of the information which is in its possession and custody. Don't wait for an order of the court. We banked on the fact that the State Bank of India would be candid and fair to the court.
But I just, whatever your lordship say, if your lordship say bond numbers, we can disclose the bond number. There's no problem.
Tell us
Somebody
one-
can screen them. And
Why has the SBI not disclosed?
I wanted to, Malad, tell Malad how we understood your lordship's judgment. Give me 5 minutes only to explain our conduct. We'll, of course, if your lordship say give anything more, everything will be given. But there's no question.
SBI's attitude appears to be, you tell us to disclose a particular detail and we'll disclose it. That's not fair process.
Malad, how we understood.
The
may
SBI
I-
requires, this is the judgment of the Supreme Court. As chairman of the State Bank of India, I'm duty bound to comply with the judgment. I will disclose every part of the information which is in my custody as directed by the Supreme Court. Because when we said all details of the purchases, that means every conceivable detail which is available with State Bank of India. And we clarified by saying including. That should be, I mean, State Bank of India has the best legal advice open to it.
May I, Malad, take your lordship through the 3 orders, so how we understood them? Malad, your lordship's first order was 12th April 2019.
Yeah.
And we have, for convenience, Malad, we have put the 3 orders together. So your lordship just see that. We'll give everything, there's no question. Just to explain that it's not that the impression which is being created, Malad, is that State Bank of India has been playing ducks and drakes with the court. I just wanted to clear that up. If your lordship sees the 12th April 2019 order in paragraph 16, but I had asked my friend to make a little compilation of the orders so we could show them easily. Your lordship has not
Yes, para 17, right?
para 16, Malad.
16. You got this?
Yes.
Yes.
This is the interim order my lords had been pleased to make. After Malad noting all the changes, the court would have to ensure that any interim arrangement that may be made would not tilt the balance in favor of either of the parties, but the same ensures adequate safeguards against the competing claims of the parties which are yet to be adjudicated. In the above perspective, according to us, the just and proper interim direction would be to require.
All right. Can we just see para 15 again, Ryan?
Yes. The court therefore has to ensure that any interim arrangement that may be made would not tilt the balance in favor of either of the parties, but the same would ensure adequate safeguards against the competing claims of the parties which are yet to be adjudicated. In the above perspective, according to us, the just and proper interim direction would be to require all political parties who have received donation through the electoral bonds to submit to the Election Commission of India and seal cover detailed particulars of the donors against each bond. The amount of each such bond and the full particulars of the credit received against each such bond, namely the particulars of the bank account to which the amount had been credited and the date of each such credit. So, my lord, your lordships felt this would ensure transparency, that you give all this, but you keep it in a sealed cover. So, my lord, a political party doesn't need bond number. If a political party comes and says, I have received so much from so and so, that gives the requisite
Salve, we
details.
take it you're not arguing a case for a political party, right?
No. On the contrary,
Hearing for the state.
I'm saying the reverse. I'm so sorry. I'm saying the reverse. But if a political
Para 16, Mr. Salve, was relating to the political parties who had to submit the data to the
correct,
to the election commission.
correct, and they have, and this has
No, that's a separate issue. Whatever they have declared or not declared, that's a separate issue. But as far as the judgment of this court is concerned, because you were
Yes.
also supposed to
I'm coming in a minute. If your lordship will just give me 1 minute, how we understood it. Para 16, with as my lord has therefore noticed, only required the political parties to give all these details. And these details have been given, my lord. If they have not been given, that's between the ECI and the political parties. As my lord, the Chief Justice said, I'm not preparing for a political party. Then, my lord, para 17 was the mechanism. Your lordship said details will be furnished in respect of electoral bonds, the details of such bonds that may be received by a political party. Up to a date for issuing such bonds as per the ministry, that is February 19, will be submitted on or before 3rd of May 19. The sealed covers will remain in the custody of the ECI. So, my lord, we had no role to play. Your lordships had put this mechanism in place. In your lordship's judgment, your lordships dealt with the diverse aspects, including the need to preserve some degree of anonymity, and your lordships will not mark that in para 125, where your lordships discuss the electoral trust as a alternative to this system. And in the conclusions, which are at para 218, if your lordships have the compilation, it would be PDF page 76.
Yes.
Your lordships will not say we direct the disclosure of information on contribution received by political parties under the electoral bond scheme to give logical and complete effect to the ruling. On 12th April, the court issued an interim direction order directing that the information of donation received from donation must be submitted by political parties. The court directed political parties to submit detailed particulars of donors against each bond, the amount of each bond, and the full particulars of the credit received against each bond, namely the particulars of the bank account to which the amount has been credited and the date on which such credit has been made. I'm only not saying this to explain how we understood the order. So this correlation between which political party has received money from whom comes in here, because the political party says, I have received so much money from so-and-so. Then it says, during the course of hearing, Mr. Sharma said that the ECI has only collected information on the contribution made in 2019 because of para 14 indicates direction was limited to contributions in that year. Your lordship then clarified para 13 and 14 of the interim order are extracted below. In the above perspective, according to us, the just and proper interim direction would be to require all political parties who have received donations through electoral bonds to submit to the Election Commission and sealed cover particulars of the donors against each bond, the amount of each such bond, and the full particulars of the credit received against each bond, namely the particulars of the bank account to which the amount has been credited and the date of each such credit. The details will be furnished forthwith in respect of electoral bonds received by a political party till date. The details of such other bonds as may be received up to the date fixed for issuing such bonds, including February 19, May 19, will be submitted on or before May 19, and the sealed covers will remain, etc. Then your lordships clarify, para 14 does not limit the operation of 13. 13 contains the direction in unequivocal terms to political parties to submit particulars of contributions received through electoral bonds to the ECI. Para 14 only prescribes the timeline for the submission on the contributions when the electoral bond should be done. In view of the interim order, the ECI must have collected particulars of contributions made to political parties through electoral bonds. In view of our discussion, the following directions are issued. The issuing bank shall stop issuance of bonds, which was done immediately. The SBI shall submit details of the electoral bonds purchased since the interim order by the court till date to the ECI, fully given, my lord. Details shall include the date of purchase of each bond, the name of the purchaser, and the purchaser of the bond and the denomination of the electoral bond purchase. All these details are given. SBI shall submit details of the political parties which have received contribution through bond since the interim order till the date of the ECI. SBI must disclose each electoral bond encashed by the political parties, which shall include the date of encashment and the denomination of the bond. Now, as we therefore understood this, the political parties have come and said, we have received so much from so and so. The details which we will give will make the database complete so that we have who purchased, when he purchased, and when they've got. If the numbers are to be given, we'll give them. There's no problem. So, according to us, the data.
Mr. Salve, I have a few questions. First, tell us in what format is the data on the purchase and redemption of electoral bonds stored by the SBI?
So, as I had explained in the application which we filed, because at that time we were functioning under the edict of anonymity, which had not been stayed. So, at that time we were directed to preserve anonymity, including we had to take measures that within the bank.
What is the format in which you maintain the data on purchase and redemption of electoral bonds? In what format do you store it?
Silos. Your Lordship noticed that in the next order. So the data is maintained in two silos.
You store it in 3 silos. From your application, it emerges now that you do it in 3 silos. The first silo is the bond number. The
bond number is only on the bond.
And the third is the redemption.
My lord, bond number is only on the bond, and it cannot be read except through under a UV light. That was only done, my lord, like authentication, because it was a bearer bond. That's what was thought to be.
The purpose of the alpha, and second question, what is the purpose of the alphanumeric?
The alphanumeric is the bond number which is visible only under a UV light.
Is it only a security feature, or is
it a security feature entirely?
In the audit trail, do you also?
No, my audit trail is separate. That's why we do the entire KYC. In the KYC, we have a bond unique number. It's not the bond number. You have a marker number of a client.
Third question. Yes. How does the redeeming branch?
Yes.
How does the redeeming branch?
Yes.
Match the electoral bond number to determine that it is not a forged bond?
So they were not. That's what I'm saying. When they received it, the person encashing it gets it. He sees that it's a valid bond because you see the security feature. You don't keep a record of it. The physical inspection.
While redeeming it, the only way you can ensure that it is not a forged bond is to match the alphanumeric. Without
there's nothing to match. It's like seeing a currency note. It's like seeing a currency note. You know that's the
alphanumeric.
Yeah.
But cashed in the last 15 days because it's only valid for 15 days. So therefore, they will have to also match when was this bond.
I think Mr. Bhushan should hold his peace for a minute.
Fourth, what is the information that you see when you scan the alphanumeric?
But do you see a number?
The details of the purchaser and the bank which issued the bond when you scan the bond?
No. That's what I'm saying. That correlation was not kept for the reason it's like this. Mr. A or Mr. B come and buy the bond. So they go to branch A. They do the entire KYC information is done, their bank account details, etc., everything is done. That is silo 1, if one may so call it, which is nothing near Lordship's. That's been fully disclosed. That bond finds its way into the hands of some political party. We don't know who gives it, how it goes, how many hands it changes. It finds its way in it. We next get to see the bond when somebody comes and says.
Mr. Salve, assuming that you construed our order based on the interim order merged with the final judgment of our court.
But even in the final judgment,
say that we will interpret our final directions in the light of the interim order, which has merged with the final judgment.
Your Lordships,
all details.
That's why we came to my lord.
Mr. Salve, we'll clarify to put it beyond any.
No problem at all.
We'll say that now SBI will not only disclose the bond numbers, but it shall also file an affidavit again before our court saying that you have not suppressed you have not withheld any details in regard to this within the purview of clause B and C of para 221.
Correct. I don't think there's anything else which remains.
Details, you have to disclose all details. Let there be because the burden should not lie upon the court or the petitioners who say, but this one has not been disclosed. But now this has not been disclosed.
Now we'll disclose it, Malad, whatever.
We must have finality to it.
Yes, we'll do it, Malad. There's no problem. Just that this constant, Malad, the media constant beating down and the petitioners giving public interviews saying we will take the state bank to task and we will show this and we will haul them up for contempt, etc., etc. But we are also public institutions working in this space. And it's all right. People work, people acted on the faith of this. Your lordships granted an interim order saying keep records. It wasn't at that time, my lord, subject to correction. I didn't find any order which says all further actions will be subject to the judgment or something. There was no such direction. Your lordships are at that balancing interim order. Now, whether completely you should lift the privacy or remove anonymity, matters your lordships will.
Mr. Salve, the idea behind the interim order was, in case the writ petition is allowed, then
Yes.
data should come out. And that's what exactly is required, nothing more.
I must say so, my lord, as out of whatever, as my lord, the Chief Justice is saying, your lordship will clarify, we will give every bit of information, relevant, not relevant, we'll give every bit of information which we have. So that, my lord, there should be no feeling that SBI is interested in somehow holding something back. I only want, my lord, to share one thing. My lord, your lordship's judgment is one of the leading judgments on the subject on transparency, voters' rights, and balancing democracy, balancing the competing virtues of and trying to minimize the role of money while recognizing the role of money in elections, etc. It goes over a lot of subjects. The one thing that lordship's judgment was not meant for, possibly, and not designed for, is to give birth once again to a now dormant PIL industry, which will go after each industrialist and say, investigate this, investigate this, investigate this, investigate that. And the idea is the voter should know, which is absolutely, and my lord say, give the bond number, we'll give the bond numbers. The voter knowing is one thing, but this as fodder for the next 10 years to have PILs saying investigate so and so, investigate so and so. That is, I don't think, the purpose of your lordship's judgment. That was not what it was meant for. And your lordship will see whatever safeguards need to be put in place.